Hello and welcome to our webinar today. The webinar today is regarding avoiding online sales pitfalls around data protection and consumer law safeguards. So I hope you're all sitting comfortably and you're ready. In the meantime, feel free to download the QR checklist on your screen right now. You can just scan it or take a photo for our supplier contracts checklist. My name is Jay. I'm one of the senior legal consultants here at LegalVision, and today's speaker will be our co-head of legal, Robert Ney. Before we begin, just a little bit of housekeeping. So you will receive the recording and the slides of the webinar afterwards in your email. They're also available on our YouTube channel, as well as all our webinars that you may find helpful. Please do submit your questions in the Q&A box and we'll answer them at the end. And also we do ask if you can complete the feedback survey after the webinar. Great. So with you guys entering the webinar today, you do qualify for a complimentary legal health check and with us to discuss how we can support your business. To claim the legal health check, please feel free to leave your details when the survey appears at the end, or you can contact us through the website. So you'll see a little poll question pop up on your screen right now. Please do answer those for us. The question is, which aspects of online sales compliance is most important to your business right now? And this is multiple choice, so feel free to tick as many as you like. The options are ensuring marketing compliance with the GDPR, avoiding fines from the IPO, understanding objections under the Consumer Rights Act 2015, managing the 14-day cancellation right for online purchases, navigating legal traps in subscription and auto-renewal terms, all of the above, or not sure, and you're here to learn. So Rob, which one do you think will get the most ticks there?
Yeah, thanks, Jay. I suspect it'll be one of the top two. GDPR, always a hot topic, so that's my guess. But I guess as everyone online is responding to the question, what I can do now is just talk through the agenda for today's webinar. So we'll go through sort of the formal part of the webinar where I'll talk through various GDPR and consumer law topics. And then towards the end of the webinar is your opportunity to be involved. So you can fill in or put in any of your questions in the Q&A box, and I'll try to get to as many of those questions towards the end of the webinar. In terms of the agenda, so I'll start off with GDPR compliance. So having a look at the key aspects of complying with the GDPR when you're selling online, and also the PECR, which is essentially the UK piece of legislation covering direct marketing. Then I'll look at sort of what the Information Commissioner's Office is doing by way of fines and how best to avoid any fines there, before moving into consumer law compliance. So looking at the 14-day cooling off period, having a talk through about this new piece of legislation, which is coming into effect. Some of the provisions are already into effect, which drastically changed the consumer law landscape in the UK. And then briefly touch upon unfair contract terms before, as I mentioned, answering as many questions as I can of yours. So in terms of that poll, let's just pop up the results, and there we go. I was accurate there, Jay. So the top three answers were in respect of marketing compliance on the GDPR, avoiding fines with the IPO, and also understanding the Consumer Rights Act. Perfect. So when we're talking about the GDPR, I mean, hopefully everyone online has a good understanding of the GDPR at a high level. But what I'll try to do today is focus on the areas of GDPR compliance from an online sales perspective, and talk through some of the things in particular with respect to marketing that you need to be thinking about to ensure that your business is actually complying with your legal obligations. So at a high level, when we're thinking about the GDPR, obviously it's the laws that cover privacy rights. So when we're looking at how to use a person's personal data, so that could be their name, their address, phone numbers, emails, images of them, anything that essentially identifies a person, what we need to be thinking about is, first of all, do we have a lawful basis to process or use that personal data? So essentially, you can't just use someone's personal data because you want to. You essentially need to link your use or your processing to one of the lawful bases under the GDPR. So some typical examples in an online sales context are where you've obtained a consumer's consent, where it's for legitimate interests. So that could be sort of marketing activities associated with your business, or performance of the contract. So if someone has engaged you to provide software, a SaaS offering, then at the end of the day, you can use personal data in order for you to actually be able to perform that contract. There's some other legal bases as well in terms of complying with a legal obligation, but for the most point, in terms of online sales, what we're typically relying on are consent, legitimate interests, or performance of a contract. So once you've sort of determined what the lawful basis is as to how you're going to be using any personal data in your business, then another important compliance aspect of the GDPR is to have a privacy policy. That needs to be available when you're collecting someone's personal data. So generally speaking, it needs to be on your website. Also, if, for example, someone is sort of signing an application form or anything like that, you should really either have the privacy policy available right then and there, like printed, or you should have a link, obviously, if they're accessing it online. In terms of consent, just quickly, and I will talk about consent at more detail when we're talking about direct marketing, but one of the things to keep in mind is consent is only one of the reasons why you might, one of the lawful bases on which you might be collecting and using someone's personal data. You don't always need to obtain someone's consent to use their personal data, but that said, there are certain types of personal data, what we call special categories, or you might have heard of sensitive data. So things like health data, data about someone's ethnicity, sexuality, etc. All of those types of sensitive or special categories of personal data carry a higher level of protection. So generally speaking, you would need to rely on consent in those circumstances. Now, when you're collecting consent and using that as a lawful basis, there's a few aspects to it. So one, consent needs to be freely given. So you can't, for example, bury consent in a set of terms and conditions. Essentially, someone needs to be freely giving consent to whatever the processing of their personal data is the subject of that consent. It also needs to be specific and informed. So it needs to be granular. If you're asking for consent to send a newsletter and to provide someone's details to one of your partners, you need to be really clear and specific as to all of the uses of someone's personal data. And if there's multiple uses, you should really have different checkboxes when you're collecting that consent. And it also needs to be unambiguous. One other thing as well is when you're collecting consent is someone should be able to withdraw their consent at any time as well. Perfect. So that's just sort of at a high level, some of the things to think about in terms of GDPR compliance. Another area of compliance which is really relevant to online sales is the PECR. So essentially the PECR is a piece of UK legislation which has rules relating to direct marketing. So that could be marketing by email, SMS, and so on. Generally speaking, when you are marketing, carrying out direct marketing online, you generally need to rely on someone consenting to receiving that marketing material. So you can't just, for example, send out a newsletter to your database of contacts. You essentially need to be looking at the people who have actually opted in to receive those marketing materials, whether it's a newsletter or another form of marketing materials. The easiest way of doing that is when someone is submitting a contact us form on your website or signing up for a subscription, ordering a product online, is to have a checkbox that gives someone the option to opt in to receive marketing materials. Now, one thing that's really important, as I sort of touched upon with consent, you need to make sure that it's expressly given. So if you, for example, you had a checkbox for marketing materials and you had it by default as checked, then that wouldn't be compliant with the PECR. Essentially, that should be unchecked until someone actually checks the box to say that they want to receive those materials. Now, there is an exception. There's two sort of key exceptions under the PECR when we're talking about receiving direct marketing. The first one being what we call the soft opt-in option. So essentially, although you usually need to rely on someone actually opting in to consent to receive marketing materials, there is an option if, for example, you are in the process of negotiating the sale of your products or services with a customer, which allows you to essentially send marketing materials about similar goods or services to that individual. But what's really important there is that it has to be, at the time that they are sort of negotiating with you on the sale. So if they're checking out their website, they're adding things to a cart, or for example, you're like discussing, you're quoting and scoping services or goods to supply to them, then it's okay to be sending those marketing materials. But there's two important things to think about there. One is that when the person first sort of engaged with you to negotiate on your products or services, they need to have been given the option to opt out of marketing materials at that point. And then in every marketing email that you're sending or SMS or so on, you need to be making sure that there is also an ability for them to opt out. So even if they've opted in once, they should be able to opt out at any point. So just make sure in your marketing emails, there's a really clear way for someone to opt out. Perfect. The other area of sort of exception is when we're talking about business customers. So if we're talking about what we call corporate subscribers, so these are essentially companies that are signing up for services or engaging with you, essentially the requirement under the PECR for express consent doesn't apply to business customers. So that might be the reason why in your business you sometimes receive emails from other businesses. That's essentially because they are relying on the fact that they're sending it to your business email address. The only thing to think about there is that, in the UK, you can operate a business through a company, a partnership, or so on, but you can also act as a sole trader. So an individual trading as a business. Now, that individual who's operating as a sole trader does not fall within this exclusion for corporate subscribers. So the requirement for consent applies to sole traders. And the last thing to kind of touch upon in terms of direct marketing is just, even if it is with a corporate subscriber, make sure that on all emails that you're sending out with marketing information, you have a clear unsubscribe option. Perfect. So obviously another area that you all indicated that you're interested in learning about is avoiding ICO infringements or fines or yeah. Now, in terms of the areas that the ICO is focusing on, so just a reminder, the ICO is the Information Commissioner's Office in the UK. It's the key regulatory body that focuses on GDPR and PECR compliance, privacy compliance. One of the key aspects is what we just talked about. So unlawful direct marketing. So for example, spamming people, sending marketing materials where you don't have consent or you're not relying on the soft opt-in option. Another aspect is not reporting data breaches. So if, for example, there is a data breach, so someone in your business sends an email to an incorrect recipient, or you get hacked, or there's, someone's left a laptop at a pub, and there is a data breach, it doesn't necessarily mean that all data breaches need to be reported formally to the ICO. But if there is a high risk or a likelihood of a high risk to the risks to the rights and freedoms of individuals, that is when it needs to be reported to the ICO. And in those circumstances, it needs to be reported within 72 hours. A couple of things just quickly on that is what's important to think about is ultimately, if you are the business that has that is acting as the controller, so you're collecting the personal data from people and there is a data breach and it to the rights of those individuals, then ultimately that obligation to notify within 72 hours falls with you. But if, for example, you're relying on third parties to assist you in providing your products or services, and they were actually responsible for the data breach. So say, for example, you had a CRM provider supporting your business and storing all of your data, and they were the ones who were actually responsible for that breach. What you need to be thinking about there is in the agreements that you've got with them, making sure that there is a shorter notification time for them to let you know that they've suffered a data breach so that you can then have sufficient time to actually report it to the ICO. Other sort of areas of enforcement at the moment from the ICO is having inadequate security measures. So, not adequate technical measures in terms of how you're actually protecting personal data in your systems and so on. And when we're thinking about ICO enforcement, what you've just got to be conscious of is they do have the ability to fine your business, and those fines can be really significant. So as you can see there, up to 17.5 million or 4% of annual worldwide turnover that your business makes in the preceding financial year, whichever is higher. So really, really significant implications associated with non-compliance with the GDPR. Will they immediately fine you in every circumstance? Maybe not, but there is obviously the potential that they can impose fines and investigate and ask you to sort of address areas of non-compliance. Perfect. So that's a bit about the GDPR and the PECR in terms of direct marketing when you're selling online. What I'll do now is just quickly talk about the consumer law. I'll start off with the cancellation right. Now, I'm sure a lot of you will be aware that essentially if you're selling online, whether it's goods or services or digital content, then typically consumers will have 14 days to cancel the contract with you. In terms of when that runs, it kind of depends. So if you're, for example, selling clothes on a website, that cooling off period of 14 days will apply from when the clothes are delivered, or if they're delivered in pieces, so there's a couple of packages going out to the consumer, then essentially it runs from the last delivery. If, for example, you were like HelloFresh and you were offering sort of a delivery of goods on a regular basis, a subscription basis, it would be from the first delivery, so the first weekly or monthly delivery of the goods. If you're offering services, it essentially runs from when you enter into the contract. So if you're offering software as a service and someone signs up for an account on your website and clicks your terms and conditions, it would apply from that point. Now, it's really important, regardless of whether you are Oh, sorry, I realized the slides were a little bit behind. Regardless of whether you are selling goods or services, it's really important to be clear with consumers as to what their rights are to cancel. And what's also really important and something you might want to think about getting advice on is whether you could potentially fall within one of the exclusions from the cooling off right. So some examples there that I've got on the screen are if you're providing bespoke goods. So let's say, for example, using that sort of clothing example, if you are selling t-shirts, but it's t-shirts that someone can, put their own designs on the clothing, then they wouldn't have that cancellation right. So you don't need to offer the 14-day right. If in a services context, if a consumer has asked for you to start performing services within the 14-day cooling off right, and they've acknowledged that they will essentially lose their right to cancel, or if they cancel partway through the 14 days, they'll have to pay you a proportionate amount, then that's sort of one of the other key exclusions. What we generally recommend from a practical perspective there is that where you've got like a checkbox when someone is signing up to your services, just pop in another checkbox saying that I'm asking for you as a business to start delivering the services within the 14-day period. And by doing so, I'm acknowledging that I'll essentially lose my right to cancel the contract. And then one of the other key exclusions, often in sort of a construction trade space, is where there's a contract for urgent repairs and maintenance. So if, for example, you're requesting, or a consumer is requesting your business as an electrician to come out to fix an issue which is urgent, then essentially they don't have a right to cool off or cancel that contract. Okay, perfect. So that is the cancellation right. Now what I'll focus on is the Digital Markets Competition and Consumers Act, which is a new piece of legislation that came into effect this year, and it's quite significantly changed consumer law compliance in the UK. What's important is that there's parts of the Act that are already in play. So the features on the slide here that I'll talk through are already in operation. But then there are other aspects of the Act which come into play at a later stage, which I'll talk to, and that sort of relates to where you're offering subscription contracts. So what's important here, there's a couple of things. One is that the Act essentially makes it a criminal offence for engaging in unfair commercial practices. Now, the Act defines an unfair commercial practice as being one that if it results in a consumer making a transaction that they would not otherwise have incurred, other than as a result of a misleading act or omission or aggressive practice or breach of professional due diligence by the business. That's a bit of a mouthful. The Act is actually quite helpful because in one of the schedules, it actually sets out what are examples of those unfair commercial practices that are essentially now illegal. Some of the key ones that I've just picked out here when we're talking about online sales, the first one being fake reviews. So essentially, if you're submitting or commissioning, incentivizing fake reviews of your products, that is now illegal, and that's an unfair commercial practice. And the Act actually goes further and says that businesses need to take reasonable steps to ensure reviews are genuine as well. The second one is quite an interesting one. It's what we refer to as drip pricing, which is essentially where at various stages in the checkout process, the pricing changes. Essentially, what the DMCC Act says is that the full price, including delivery costs, absolutely everything that the consumer has to pay, needs to be set out and really clear when someone is paying for the goods or services. And then there's a few other aspects of unfair commercial practices, which are set out in the Act as well. So pyramid schemes are finally illegal. Selling pass-off, so selling fake products or fake versions of reputable and well-known products in the market. And then also misleading consumers as to the availability of a particular product. So if, for example, you were saying, hurry and buy this product because there's only 5 left, but in reality, there were actually hundreds on stock. That's also seen as an unfair commercial practice and illegal. Great. Now, in terms of, as I said, those changes with respect to unfair commercial practices that I just ran through, they are already in play at the moment. So you need to be complying with them right now. Now, in terms of where you're offering your product or your services on a subscription basis, there are changes that are coming into effect next year. We're still waiting to know exactly when they will come into effect, but we've been told it won't be earlier than spring 2026. So spring next year at the earliest. And we're sort of waiting on further guidance on that point. But in effect, what the new Act is targeting is subscription contracts and making businesses be a lot clearer with respect to the scope of a subscription, so exactly how much a consumer will have to pay, including across the whole duration of the subscription, information about the cooling off right, and noting as well that the 14-day cooling off right now, well, in the future, when this comes into effect, it will actually also apply to renewal periods of more than 12 months as well. So if you're offering services on a rolling 12-month subscription basis, essentially the consumer will have the 14-day cooling off right when they first enter into the subscription, and then each and every renewal period after that. It's really important as well in noting that now as a business, if you are offering a subscription, you actually have to provide regular reminders about the rights to terminate subscriptions and clear communications with respect to renewals of subscriptions. As I said, we're sort of waiting on this point in terms of receiving further guidance from the CMA to see exactly what the requirements are in terms of when the notices need to be given and so on. It's kind of watch this space, and obviously the changes aren't into effect at this stage. So we're just waiting to see exactly how clear you need to be in notifying. But what I would just say is if you are offering products on a subscription basis, just keep in mind that we're moving towards a situation where you can't just have a contract roll over automatically without informing a consumer that that's going to happen. And just to recap as well, this is all targeting consumer contracts. So it's not targeting contracts that are B2B between businesses. One of the other key aspects of the Act is the ability for the CMA, being the key regulator in the consumer law space, to take enforcement measures. So previously, in terms of the CMA's ability to fine businesses, they previously essentially had to go to court. and obtain an order, and then it would essentially be the court who would fine a business. That has changed with the Act. So the Act enables the CMA to issue fines for non-compliance. And once again, similar to sort of the ICO's ability to enforce and put out fines, they are quite significant. So you can see here for certain types of breaches, like substantial breaches, you're looking at 300K or 10% of global turnover, whichever is higher. So really, really significant powers for the CMA to enforce. And as I said, they don't actually have to go to court anymore to impose those fines. So really important to keep across all of the changes here, particularly with respect to the subscription changes that are coming into effect next year, to make sure that you are fully compliant. All right, so just the last section. I know we've covered a lot. We've obviously covered a lot of areas of GDPR compliance and also consumer law compliance as well. One of the other things I just wanted to briefly touch upon, and we have previously done other webinars on unfair contract terms as well. So as Jay said, you can check out our YouTube channel and see some of our other previous webinars there. But in terms of unfair contract terms, in the UK, there's specific legislation for B2B contracts and also B2C contracts. Those two pieces are separate. But essentially, the consumer law unfair contract terms are more extensive than in a B2B context. And the effect of having an unfair contract term is that it's unenforceable. So, for example, if you've got T's and C's on your website that are sort of provided on a take it or leave it basis, essentially, if a consumer was to successfully challenge one of those as being unfair, then they're unenforceable and you can't rely on it. Now, at this stage, there's not specific penalties for unfair contract terms in the UK, unlike some other jurisdictions. But given the changes that we've seen to the consumer law this year, I wouldn't rule it out that at some point, the government might look to impose penalties for having unfair contract terms in your terms and conditions in your contracts. So really important to get them legally reviewed to make sure that you're meeting your obligations there. Okay, so that's the formal part of the presentation today. I know there's a lot to stomach there, so hopefully you're still with us. I'll throw over to Jay just with a couple of reminders, and then just a reminder, keep popping in your questions, and I'll answer those really, really shortly.
Amazing. Thank you so much, Rob, for that. That was great. Yeah, so this concludes the main part of our webinar. Just in case you missed it earlier, do scan the QR code on your screen right now for a supplier contracts checklist. It's a very helpful piece of resource. So yeah, keep that. You guys may also be interested in our upcoming webinar. We do them regularly. The next one we have is around the legal implications of breaking a commercial lease. And this will be on Tuesday, the 23rd of September at 11 a.m. Do feel free to register with the link below. Great stuff. So we will answer your questions shortly. While you submit them, I would like to take a minute to tell you about the LegalVision membership. So by becoming a LegalVision member, your business will get access to a full team of specialist lawyers for all your business as usual legal needs. There are lots of things our team can support you with. Things like unlimited legal advice consultations, unlimited documentation drafting or reviewing, and even domestic trademark registrations and lots more. So as a LegalVision member, you wouldn't need to worry about the cost of lawyers again. Think of it as your own in-house counsel, really, but a fraction of the cost. We'll take care of all your business as usual legal work, so you can focus on running your business. And if you do happen to be an in-house counsel yourselves, we do also offer a dedicated service to manage your high volume business as usual legal tasks. So to learn more about how the membership or desk section can help you in your business, request a free consultation when the survey appears at the end of the webinar. Great stuff. So we'll move on to the Q&A. Yeah, I'll pass over to you, Rob. Thank you.
Perfect. Thanks, Jay. So yeah, just keep those questions coming through. I've had a few come in, which is really, really good to see. The first one, this is an interesting question, actually. So it's talking about fake reviews, which was one of the unfair commercial practices that I was talking about being illegal now. So the question is what is the difference between fake reviews and incentivized reviews? So that's a really good question. So essentially, fake reviews are banned. So if you've got a family member who hasn't actually paid for your goods or services posting a fake review, that is banned. But if, for example, you are engaging an influencer to post a review about your product, that is okay. But what you need to make sure is that it's actually genuine. And if there has sort of been like a discount that the influencer has obtained or they've been paid or something like that, you need to disclose that as well. So what you'll often see on social media like Instagram is you'll see sponsored posts that clearly set out that a business has essentially paid for that review or for that rating of their product. Perfect. The second one I've got here is if someone buys something online from us, how long do they have to return it? That's also a good question. So I think there's a couple of things to point out here. One is that there's the cooling off right that might apply. So the 14-day cancellation right, if it does apply and it's not subject to one of the exclusions that I was talking about. So generally speaking, if someone buys something online, they have 14 days to change their mind. But what I would say as well is that's only the cancellation right. What you've got to be thinking about as well in terms of consumer law compliance is obviously if there is an issue with the services or the goods that you're supplying, then consumers have broader rights. So for example, if you sell a product and there's a defect, essentially they have a right to return the product, ask for you to fix the issue, send it back out to them. There are sort of other rights in terms of price reduction as well. Also entitlements to refunds in certain circumstances. So just keep in mind that the 14-day cancellation right isn't all that you need to do from a compliance perspective. You still need to make sure that the consumers have the benefit of the statutory guarantees under the Consumer Rights Act. Okay. If we have a data breach, how do we report it? So I sort of touched upon this, but essentially, if there is a high risk to the rights of individuals, then that is a reportable data breach. It doesn't mean that absolutely every time you have a data breach, you need to report it to the ICO. It all turns on whether there is a high risk of harm to individuals. Now, the ICO is actually quite helpful. On its website, there's a number of tools that you can sort of use in your business to determine whether you need to report something. But if you've ever got any questions about whether something is reportable to the ICO or not, just reach out to us ASAP because it's really important to note that the 72 hours is a really short turnaround time. So you need to make sure that you're complying with your obligation if it is the type of breach that is reportable. We've got just a few more minutes. If anyone else has any other questions, now's your last chance to pop them in. Let's just see what other ones we have here. Okay, what happens if I don't provide clear cancellation information to customers? Interesting. If you haven't informed a consumer that they have the 14-day cooling off right, essentially that cooling off right gets extended and it can be extended for up to 12 months. So essentially you just need to be giving information about the cooling off right. What I would say though, and sometimes you might get a little bit confused because sometimes you see online retailers, particularly the larger retailers like ASOS offering a longer return policy. So for example, 30 or 60 days. I mean, they might, as a business, not specifically talk about the 14-day cooling off period, because at the end of the day, they are going above and beyond their obligations. So there's nothing to stop you from providing a longer period, provided that you're meeting the minimum 14-day cooling off period, unless, again, you fall within one of those exceptions. And in terms of those exceptions, I mean, they can be a little bit tricky to determine. So if you've got any questions, again, just reach out to us. We can make those determinations on your behalf. Perfect. Any other last minute questions? Otherwise, what I will do is I will hand it back over to Jay just quickly, and we can wrap up the webinar today. But yeah, from my perspective, thank you so much for joining. Hopefully I got to answer some of those questions. If you do have any other questions as well, feel free to pop them in the feedback survey at the end of the webinar also. Over to you, Jay.
Amazing. Thank you so much. Yeah, and thank you everyone for joining us today. Please do submit your details in the survey at the end, not only to go through any questions that maybe didn't have a chance to pop over today, but also to learn more about how our membership can help you. While this is a free webinar, we do really value your feedback. So please do complete the survey and let us know, how we can do better for next time. Yeah, thank you so much for joining us today, and we hope to see you next time.
Thank you, everyone.